Welcome again to the Mailing Law YouTube channel, where we talk about different estate planning topics relevant to people living in Utah. Today we're completing our little series about what to do when a loved one passes away. And hopefully it doesn't come to this, but a lot of times you do have to go through probate to administer an estate. And whether that's by design or usually more commonly by accident, there are a few things you can do to make sure the probate process is as simple as possible. Now to kind of set a stage here, we only really have to do probate in a few different situations. Number one, it's less than 3 years after the death of the person who passed away. Two, the assets are subject to probate. So that's going to be bank accounts worth more than $75,000, or any real estate, or anything registered through the DMV. If they had more than 4 in their name, then we've got to go through probate. The probate process can be fairly straightforward, fairly simple. A simple probate between court fees and publication fees and attorney fees can cost as little as about $2,000, but generally it tends to be quite a bit more than that. The things that you can do as an administrator to make sure that the probate process is as simple as possible are kind of as follows. First of all, you need to make sure everyone's on the same page. If anyone in the family wants to dispute the will or dispute distributions or whatever that may be, then we're automatically kicked into a formal probate process. It's going to be much more expensive, and it's just a huge pain. But when we can stay within the informal probate process, that really helps us out quite a bit. So if everyone in the family is on the same page, if no one's going to contest, and if everybody in the family is willing to sign what's called waivers of notice, that kind of shows to the court that everybody in the family is aware that this probate process is going on, and that that it's going to be administered properly. And this is really anyone like a surviving spouse, descendants, and sometimes siblings as well. It depends on how the family structure is. But these pretty much any descendants plus a spouse, and sometimes out to siblings or parents or any nieces and nephews, depending on how the will is structured. If all of these people are okay with whatever the process is, and we kind of have a feel for what the distribution structure is ahead of time, that really speeds up the process. And once it does get time when you're about to file for the probate, you want to make sure you have those waivers of notice signed and notarized from everyone in the family. Any probate attorney can help you obtain those, but that really does speed up the process quite a bit. If you have those waivers of notice, you have a death certificate for the person who's passed away, as well as a spouse if the spouse has passed away. The will, if there is a will, any revisions or updates to the will that there may have been, as well as a list of assets. Then an attorney can use that information, give you all the forms you need, get them submitted to the court, and then within sometimes as little as a few days or as long as a few weeks, you will have authority from the court to start administering the estate. After that point, with a few steps followed, you can close the estate in as little as a few months, but it can take longer than that depending. So if you are going to be administering the estate of a loved one, just be aware that the probate process can be simple, but everyone needs to be on the same page. So start assembling that information as quickly as you can, and letting everybody know that you're going to need that information so that you can administer this estate within a timely manner, and so this estate doesn't become a point of contention. Thanks for watching. If you have any other questions for us on how to administer an estate in Utah, or what you can do to mitigate any kind of possible dispute, because that's really where the costs come into play, then feel free to give us a call.